Hello, good morning, good afternoon, good evening, depending on your time zone. Welcome to my YouTube channel. My name is Ogbanje Joseph. Please subscribe to this channel, like and share this video, as well as drop a comment on the comment section. Today, we're going to be looking at international law and the settlement of international disputes. International law and the settlement of international disputes. The preamble of the United Nations organization says that the United Nations is established for the purpose or for the peaceful resolution of international disputes. In fact, paragraph 1 of Article 1 of the United Nations Charter states that the purpose of the United Nations is to maintain international peace and security, and to that end to take effective collective measures for the prevention and removal of threats to the peace and for the suppression of acts of aggression or other breaches of peace, and to bring about by peaceful means adjustment or settlement of international disputes or situations which might lead to a breach of peace. So, ab initio, okay, the establishment of the United Nations organization was basically on the premise of the maintenance of international peace and security. International peace and security. Okay, so to take effective collective measures for the prevention and removal of threats to peace, and for the suppression of acts, okay, or other breaches of peace. Okay, so the United Nations organization is there to ensure that everything that will actually hamper or jeopardize world peace is properly and adequately dealt with. In fact, they are expected to be proactive to ensure that everything that has to do with threats to peace is suppressed. Every act of aggression is actually done away with, and every breach of peace is actually treated very squarely, and then bring about peaceful means, adjustment and settlement of international disputes, and of course, situations which might lead to a breach of peace. Okay, so consequently, disputes that can be resolved through peaceful means, okay, or coercion, is what the United Nations organization is actually there for. Okay, if it is peaceful method, you have things like arbitration. Okay, you have things like judicial settlement. You have things like negotiation, mediation, inquiry and conciliation. You have coercive, and on the other hand, the coercive means actually involves war, retortion, reprisal, countermeasures, blockade, and intervention. All of these things are actually both peaceful means, you know, of resolving international conflict, and then we also have coercive means of resolving international conflict. Now, we're going to take a look at all of them one after the other. Now, let us look at negotiation. Now, what is negotiation? Now, most disputes, okay, which arise between states are settled through the normal channel of diplomacy, which is by negotiation between diplomatic representatives. And by negotiation, I mean the bargaining process, the back and forth that actually exists between two or more representatives of parties that are involved in a conflict. Now, these efforts may be supplemented by meeting of foreign ministers or even of heads of states, by international conference, or by resorting to machinery provided by the United Nations organization or a regional organization such as the AU and all of that. But the first step, whenever a dispute arises, is invariably direct negotiation. Direct negotiation. A very good example is what is happening in Mali, that ECOWAS actually has sent a series of representatives. You know, the Nigerian government has also sent series of representatives to the to the coup leaders in Mali, for them to actually drop, for them to have a negotiation and then restore democratic institutions there. But unfortunately, the relatively few instances in which this procedure fails are likely to be most serious ones, okay, involving real threats to peace and security. This is because the devices of diplomacy tend to break down in crisis situations. Hence, in order to avert serious consequences, other methods for peaceful settlement of disputes have also been deployed. So negotiation, like I said, is the bargaining, is actually a diplomatic means in which people, parties in conflict sit down, to really, explore avenues, okay, or bargain, the process of actually ensuring that there's peace, between the two warring parties or the groups in conflict. So the second is good offices. Number two, okay, number two, pacific, means of settlement in the international, uh, that is settlement of international dispute in international law, is good offices and mediation. Number two, good office. Number one is negotiation, which is what I've just explained. Number two is good offices and mediation. Now, what is mediation? Mediation is actually a third party intervention in a conflict resolution process, okay, in which case the third party, now if a third party offers to be of service in attempting to compose differences between two other states, it is said to tender its good offices. What am I saying? What I'm saying is that, you know um mediation here is a third party intervention in conflict resolution process, in which case a mediator is expected to actually mediate or try to strike a balance between the parties in conflict. Now, under this, if the offer from the good offices of a mediator is accepted by the disputing states or parties, the good offices may lead to mediation. For example, now let's look at it this way, that the difference between the two, that is the good offices and mediation, is that in good offices, the third party acts simply as a friendly go between, okay, whereas a mediator may make suggestions of his own. Now, let us get an example. For example, in 1905, President Roosevelt tendered his good offices to Japan and Russia to end the Russo-Japanese War. Now, the offer was accepted, but he actually became a mediator for the exact, for he exerted a direct influence in averting a threatened impasse in the negotiations and in bringing about intimate agreement. Now, Russia and Japan were not bound in any way to accept his suggestion, but they saw it fit to do so. So the United Nations has also performed many useful services in the field of negotiation, either through individual mediator or through one of its agencies. For example, the use of individual mediators would rather be the effective rules of Count Falk, Bernadotte, and Ralph bunch in the delicate negotiation which led to an armistice between Israel and Arab states, of Dr. Frank Graham in connection with Kashmir dispute, and the former Secretary General Dag Hammarskjöld himself in series of crises. What I'm trying to say here is that you have good officers, but these good officers can actually turn to mediation. Okay, so now let us look at number three. Number three is conciliation. Now, closely related to and often more effective than good offices and mediation are inquiry and what and conciliation. Now, the first Hague Conference recommended the use of commissions of inquiry. The second Hague Conference renewed this suggestion, and provision for such provisions has been incorporated into many bilateral and multilateral treaties. The Assembly of the League of Nations strongly endorsed the idea in 1922. In spite of all these, however, the use of commission of inquiry has been negligible. So when we talk about conciliation here, we are actually looking at an inquiry that is done into a crisis situation, and after the inquiry has been done, then the two parties actually are made to the two parties are the ones that will actually point at the conciliator. The conciliator comes and, of course, offer his own suggestion for the crisis to actually be done away with. Okay, so conciliation differs from inquiry in that it assumes an obligation on the part of third parties to take the initiative in the search for agreement. Okay, so that is conciliation for you. Okay, now let us look at the next one. The next point is arbitration and judicial settlement. Okay, now judicial settlement is also referred to as adjudication. Now, it is referred to adjudication in the sense that a form of adjudication, in the sense that it is done by a permanent court or a tribunal. Now, when we're talking about adjudication, we're actually talking about either a court or a tribunal. Now, the judgment of the court, the judgment of the ICJ, for example, or International Court of Justice or International Criminal Court, all of those judgments are actually, judicial settlement of disputes at that international level. Okay, so those are the things. Now, the boundary between let's look at it now. The boundary between between arbitration and adjudication, okay, is actually not very clear. In fact, it is very blurred. Okay, but what is important is that we must understand the fact that both arbitration and adjudication are actually, or a judicial settlement are both both arbitration and judicial settlement are adjudication. They are both adjudication. So at the end of the day, it is actually a legal process in which international dispute is put to rest. Okay, so that is actually for that. Then we have coercive means of settlement. What is coercive means of settlement? That's the use of force to actually settle international dispute. And what are the examples of this? We have number one, retortion. Now, what is retortion? Retortion, is the use of retaliation for the lawful act of another state which was harmful to the retorting state. For example, severance of diplomatic relations, expulsion of foreign nationals, restriction of movements, etc. These acts were and still are within the law. Okay, so that is retortion. Retortion is actually like retaliation for lawful act of another state. So, for example, when Nigeria under Goodluck Jonathan, okay, saw that the South African authorities actually refused Nigeria airplane to actually land in South Africa, or that the airplane has actually landed and all the people on board were checked and they saw that a lot of them were not having the yellow card. Okay, so they were all returned back to the country. And of course, Nigeria, in retaliation, that is in retortion, decided to say, okay, every plane that is coming from South Africa must not land on the space of Nigeria. Okay, must not land or must not even come into the space of Nigeria unless they withdrew that action and then they actually apologize on national dailies, which the South African authorities actually did swiftly. Okay, that is retortion. Now we also have reprisal. This is an act to compel a state to comply with the law consequent on the state's delict. For example, it could involve the seizure of property and detention of persons. Okay, so those are the things. Now, reprisal must be preceded by a demand for redress, which was ignored. The act must be proportionate to the injury suffered. It must be necessary in order to secure compliance with the settlement. So, reprisal is actually, it is different from retortion in that reprisal is illegal per se. Retortion is legal, reprisal is illegal, but only justified by the earlier commission of the act by the other states. Okay, so that is actually for reprisal. Then we have armed intervention. This is done by a single state or group of states in the domestic or foreign affairs of a state and was calculated to maintain a state of affairs favorable to the interveners. Okay, favorable to the interveners. A classical example is ECOMOG intervention in 1995 in Liberia to quell a civil war that followed the overthrow of the government, and later in Sierra Leone to remove a military junta that ousted the president. Okay, so those are the things. That is armed intervention. Then we also have humanitarian intervention. Humanitarian intervention here, okay, is actually recognized. Okay, it is actually where the foreigners were entitled to actually give treatment to people that are actually needy within a country. So the principle of sovereignty was traditionally given a wide interpretation and covered all aspects of state's treatment of its own subjects as matter within its domestic jurisdiction. It, however, recognized that foreigners were entitled to minimum standards of treatment, a breach of which incurred international responsibility. The practice that then developed that a state's treatment of its own nationals invited external intervention if it degenerated to a level that shocked the conscience of mankind. So if the human rights of people within a particular country is being trampled upon, or there is a particular level at which human beings are supposed to actually live, okay, if the minimum standard of that is actually not met, of course the international community can come up with humanitarian intervention to shore up or to meet the deficit. Thank you very much.